Mary Louie and Monica Douglas, two black women in Massachusetts, were denied housing in May 2022 despite holding federally funded vouchers. SafeRent's Registry ScorePLUS algorithm scored them as high lease performance risk. The model weighted traditional credit history heavily and excluded the guaranteed monthly income provided by their vouchers entirely. In November 2024, the case settled for $2.275 million. Louis v. SafeRent is not a vendor error. It is a structural diagnosis of how predictive models encode historical credit disparities into housing markets. HUD's May 2024 guidance makes the standard explicit. The measure is disparate impact, and intent does not matter. The EU AI Act now formally classifies tenant screening algorithms as high-risk systems subject to mandatory conformity assessment. The era of algorithmic exceptionalism for housing software has closed. The neutral vendor defense is dead. As of October 2021, the median credit score for white consumers was 725. For Hispanic consumers, 661. For black consumers, 612. When a screening model treats credit history as a neutral predictor of lease performance, it does not measure reliability. It inherits a century of differential access to credit. Wrapper systems compound this failure in two ways. First, they cannot generate the reason code disclosures required by the Fair Credit Reporting Act when a tenant is denied. Second, without adversarial debiasing at training time, no post hoc explanation layer can remediate a model optimized for accuracy alone while ignoring its disparate impact ratio. SafeRent deployed a model of exactly this type. Correcting for structural credit bias requires three distinct interventions at different stages of the model pipeline. Pre-processing targets the training data before the model trains. For voucher populations, this means explicitly resampling successful voucher holders to counterbalance underrepresentation in historical rental records, applying differential reweighting so protected class applicants contribute equal statistical influence, and generating synthetic voucher holder profiles to close representation gaps. In processing modifies the optimization objective. This is the core of deep AI. The model trains alongside a secondary discriminator network, whose sole task is to predict the applicant's protected class status from the primary model's outputs. If the discriminator succeeds, meaning the primary model's predictions still carry protected class information, the primary model incurs an adversarial penalty. This forces the network to learn features genuinely independent of race, voucher status, and national origin. Post-processing calibrates the decision boundary. Equalized odds requires that the true positive rate, the fraction of credit-worthy applicants who receive approval, be statistically identical across all demographic groups. Where the model's raw threshold would produce differential approval rates, the threshold is recalibrated per group until both approval and rejection rates equalize. The Fair Game framework wraps these three pillars in a continuous reinforcement learning loop. An algorithmic auditor samples model input-output pairs and estimates the disparate impact ratio at regular intervals. A debiasing agent adjusts model weights based on the auditor's feedback. Human-in-the-loop preference signals close the outer loop, embedding legal and ethical judgment directly into the ongoing training signal, ensuring the system adapts as new case law or demographic data becomes available. The mathematical foundation of the SafeRent litigation is the disparate impact ratio. Formally, the ratio of the positive outcome rate for the unprivileged group divided by the positive outcome rate for the privileged group. Regulators apply the 4/5 rule. A ratio below 0.8 is prima facie evidence of prohibited discrimination. SafeRent's failure to account for voucher income almost certainly drove the disparate impact ratio for voucher holders significantly below this threshold. Model multiplicity research establishes that this failure was preventable. For any real-world dataset, there exist millions of models that achieve statistically equivalent predictive accuracy, but with profoundly different fairness profiles. A systematic search for the least discriminatory alternative, the LDA doctrine, required under disparate-impact law, would have identified a model capable of predicting lease performance without encoding the voucher credit correlation. SafeRent conducted no such search before deployment. The settlement terms reflect the court's technical conclusions. SafeRent may no longer issue automated approve or decline recommendations for voucher holders until civil rights experts independently validate the model. That validation requirement runs for 5 court-monitored years. SafeRent's legal team argued that as a technology provider and not a landlord, the company was not subject to the Fair Housing Act. The court rejected this. If a landlord relies solely or primarily on a third-party algorithmic score to make housing decisions, the vendor of that score is integrated into the decision chain and shares liability. This ruling applies to every enterprise that builds, licenses, or deploys automated screening software in regulated environments, housing, lending, employment. The question for Enterprise Risk Counsel is no longer whether to invest in adversarial debiasing and LDA certification. It is whether to begin that investment before or after the settlement notice arrives. We built this paper to walk through the SafeRent anatomy and the 3-pillar fairness architecture in technical detail. Read the 14-page brief, approximately 17 minutes, and see exactly what a defensibly fair housing model requires.